morning, ladies and gentlemen. So today, the focus of my presentation is going to be on enforceable undertakings, particularly in the context of ASIC's response to the Hennie Royal Commission that's recently passed. So it's going to be split into two parts. One, I'm going to describe ASIC's response to the Royal Commission, and secondly, I'm going to question that response and whether it's the right appropriate response given customer interactions and outcomes, and whether that's the most effective outcome in the end for customers. So if we go look at what enforceable undertakings are, they're negotiated outcomes or settlements between ASIC and a regulated entity, and they're accepted as an alternative to court litigation, effectively. And so enforceable undertakings are entered into under sections 93 and 93 AA of the ASIC Act, as well as under the National Consumer Protection Act as well. And effectively, they're voluntary undertakings. So ASIC cannot compel an entity to enter into them, but they nevertheless are court enforceable. So if an entity fails to comply with them, then ASIC can take them to court and have that enforced. And subsequent non-compliance can be found in contempt of court. And ASIC's approach to enforceable undertakings is from Regulatory Guide 100. And effectively it says that ASIC won't enter into any enforceable undertakings unless a suspected contravention has occurred and an investigation has commenced. And they won't be entered into unless they afford a more effective outcome, effectively. So there's effective regulatory outcome if it promotes the integrity of and public confidence in financial markets, specifically deters the person from future instances of misconduct, promotes general deterrence, or provides an ongoing benefit. So it's not that EUs will be used in every circumstance, it's only when there are more effective regulatory outcome than other particularly relevant outcomes. So if we go to the Royal Commission itself, it certainly was a strenuous and a very problematic time for the financial services industry. Particularly Commissioner Shang was very critical of the regulated industry. But not only the industry itself, but the regulators. So you have ASIC and APRA and the other regulators, secondary regulators in the financial sphere, being hammered by the Commission. Particularly in terms of being too close to the industry, too willing to compromise, too willing to listen to the express wishes of the entity without considering ramifications or what should be done in light of the law. So specifically, Commissioner Shang talked to the lack of admissions when it came to enforceable undertakings, because entities only accepted ASIC's concerns rather than admitting any wrongdoing. So he pointed to the flexibility of enforceable undertakings, but ultimately concluded that they should really be an aid of enforcement, not in substitute of enforcement. And so eventually he came to the point where it's the oft quoted "why not litigate" approach, where it's unless it's in the plain public interest not to litigate, then we should be litigating, and they should remain under active consideration. And so we can see some of the negative headlines that came out of the Royal Commission. Certainly, almost every day there was another headline about ASIC failing to do this, a bank failing to do that, etc. And so there's a lot of public, pressure and a lot of government pressure to get things moving. And when you have, a different approach or a new legislation in that kind of an environment, then it's critically important to pause and reflect, and not just rush into things because it's, politically, appropriate or politically attractive to do so. And so, it's hardly surprising that ASIC was kind of forced to act because, it listened very keenly and quickly. So the new chairman, James Shipton, has clearly said, the mandate is crystal clear. If the law is broken, we need to enforce it. And so it's hardly surprising that they did establish an office of enforcement, like a US litigation style under the SEC in the US, following an October 2018 internal review by Deputy Chair Hennie. And it's focused on deterrence, public denunciation, and punishment of wrongdoing via litigation. So it's very clear. And there's a 6-month time frame between ASIC receiving a notification or a misconduct and breach and deciding to prosecute or not, which is a very strict timeline. And there's no negotiation until the end of an investigation. So there are 3 questions to ask. Is ASIC satisfied that breaches are more likely than not? If yes, is it evident from the facts of the case that the pursuit of the matter is in the public interest? And if that's yes, then the question is, why shouldn't we litigate? And so, another thing is to look at the drivers of this kind of push. And so an understated thing is really just personnel changes that have happened at the top of ASIC. James Shipton, who's the new chair, is a former banker and regulator at the Hong Kong Securities and Futures Commission. And he replaced a more controversial chairman, Greg Baycraft, who was seen to be too close to the industry. He had been a securitization veteran for 30 years at the French Investment Bank Société Générale, as well as being a top regulator in the international sphere, being chairman of the International Securities Commission and organization. And so people complained that ASIC's mandate was diluted. Too many enforceable undertakings were being entered into, too many negotiated outcomes. ASIC Deputy Chair for Enforcement, Daniel Crennan, that's a new position created. He's a former barrister now, and he's been quoted being very litigation friendly, etc. Karen Chester, who's the ASIC Deputy Chair as well, she was a former Productivity Commissioner Deputy Chair, and she led in 2016 a very scathing review into ASIC, saying ASIC was internal looking, was very insular and afraid to prosecute test cases especially. And you have Sean Hughes, who was a previous CEO of New Zealand's Financial Markets Authority, and he's been quoted saying, it's inevitable that there's more litigation, and he's not afraid of reducing the success rate of ASIC. And so it's hardly surprising that you see these changes. So another thing to mention is the political mandate, which I referred to before. The government's injected multi-million dollars into ASIC, particularly to improve enforcement outcomes. You have $70 million in August 2018, and in the recent budget in April, $404 million injected into ASIC to help it implement its new enforcement strategy. And it's very clear that on both sides of government, there's bipartisan support to enhance the enforcement outcomes of ASIC. And just one more thing is the new penalties regime that came in March 2019. So there have been over 60 new additional penalty provisions, and it's vastly expanded the scope of what's considered criminal and what's considered a simple penalty. And ASIC's been imbued with disgorgement remedies, and there's been things like the subjective element of dishonesty is being changed into an objective element now. It's made it a lot easier for ASIC to prosecute cases, and that's been noted in both the Royal Commission itself, where it says the use of EUs may be expected to be less frequent now. That was even before the changes had come in March. And ASIC's noted that both Deputy Chair Crennan and Chairman Shipton have said, we expect EUs to be used much less, and we expect there to be much more litigation. So you can see this in the numbers themselves very clearly through the empirical data. So I've tabulated all the EUs that have come across in the last 20 years since they were first introduced in 1998. And you can see in 2019 there's been just one EU as compared to an average of 20 over the last kind of decade. And that was in February itself. So there have been none since February, and the vast majority of those in 2018 were in the first half. So you can see that this is a very clear decline, and that comes from the political mandate that's emerged. So on the right-hand side, you can see that court enforceable undertakings still remain necessarily like a very small percentage of all outcomes, to 2 or 3% range. So anyone that says that there are too many or that there are too much or there are way too many negotiated outcomes isn't looking at the numbers necessarily, because there are a lot more summary prosecutions, a lot more criminal prosecutions, and a lot more civil litigation as compared to enforceable undertakings. So I'm going to move into the second half of my presentation, which is about assessing the validity or whether it's actually effective or not, this new strategy. So we need to look to some regulatory theory. So the traditional regulatory theory that underpins enforceable undertakings is that of responsive regulation theory, which is espoused by Ayres and Braithwaite in 1992. And so it's based off an enforcement pyramid on the right-hand side, as you can see. So on the bottom of the pyramid, you have more persuasive elements like enforceable undertakings and warning letters, etc. And as you move up the pyramid, as you scale the pyramid, you get to more heavy-handed remedies like license suspension and criminal penalties, etc. So it's designed to get regulated entities to comply with the bottom of the pyramid, because that's where the resource efficiency is. Compliance is incentivized when you have big sticks but you're not afraid to use them. But nevertheless, you don't use them unless absolutely necessary, because they're inefficient. Because the true mark of power is the discretion not to use power in a sense. So there are two drivers traditionally in the literature that people point to that are drivers of a corporate actor's decision to comply with the law. On the left-hand side, you have compliance based on economic rationality, which is cost-benefit analysis, and on the right-hand side, you have more altruistic drivers. So on the left-hand side, if you have an enforcement strategy that's focused too much on the base of the pyramid, well, then it's obvious that it's going to be exploited. And you have actors that act solely on the basis of economic rationality, which is arguably what has been happening and it's been picked up by the Royal Commission. But what I'm afraid of is moving too much to the other side, which is compliance. If you're going to the top of the pyramid over here, then you're disincentivizing altruistic notions, and you're creating perhaps a negative culture. And so I'm going to question whether a litigation-friendly approach is really the correct way to move forward. Because litigation, let's face it, is incredibly expensive, right? It is also binary. It's a zero-sum game. There are winners and there are losers. What happens if ASIC loses a case? Is that effectively an endorsement of the regulated entity's conduct, for example? And ASIC loses its ability to control the direction of the compensation because it's handed its powers to a court effectively. So you don't have the subsequent monitoring and flexibility that you do of the negotiated outcome. And basically, you have a less of an impact on customer remediation outcomes because you have in a court environment, they're not going to ask you to make a specific targeted remediation program that's going to be monitored subsequently. It's going to be heavy-handed, and it's going to be a penalty, and it's a final penalty, which is usually just a straight monetary sum. So it's also going to create a culture of antagonism and brinksmanship and adversarialism, which is not necessarily conducive to the altruistic things that I've just talked about before. And litigation is expensive. There's almost $60 million a year is spent on it, just on enforcement outcomes through ASIC. On the right-hand side, you can see that there's been a 126% increase in the last 2 decades of the number of registered companies under ASIC's remit, but only a 35% increase in the number of actual staff. So it's a necessary pragmatic consequence that not everything can be litigated. And so I'm just looking at what the industry says itself. Last year, a group of academics did a survey on the industry itself and asked actual industry professionals. And the general consensus is that EUs are effective. They do provide a deterrence effect. They're not soft in terms of expense, management time, and the resources of management. And they provide an educative effect where people can look to best practice from other enforceable undertakings and say, we should be doing this, etc. So it creates a kind of virtuous cycle throughout the industry. And it is a much more swifter form of justice, and it meets the celerity element of deterrence. But just the last slide, and just comparing the two, the litigation approach in blue and the enforceable undertaking approach in orange, you can see that they don't cover the same field, and which really leads to my final point, which is that they should be complements to each other. They shouldn't be substitutes to each other. Both should be retained because they do different things. Enforceable undertakings are much more on the flexible side, the expedient side, and the resource efficiency side. And they should be used for those lower level infringements because they're a lot more resource efficient. Litigation should be reserved for the most egregious offenses, ones that really require the retributive justice, the deterrence effect that only litigation can bring. That's not to say that enforceable undertakings can't be improved. There's issues around transparency, around admissions of guilt, around deterrence, around monitoring that really can be pushed. So some of the orange over here can move into the blue over here. And so ultimately, in conclusion, it's really important to not let the pendulum swing too far to the other side, I think. And it's important to stop, pause, and reflect whether this is the right approach that we should be taking. Because ultimately, the customer, the aggrieved customer, needs to be compensated effectively. And it's not necessarily that litigation will bring the results that it's been espoused to bring. Thank you very much, and I'd be happy to take any questions.
Look, I thought that was a very good presentation. Before we get into comments with we've got a few questions.
Sure.
One of the ones I have is that, do you think these pretty probing questions about enforceable undertakings would have arisen without the Banking Royal Commission?
In response to that, yes, I do. Not necessarily as publicly, announced in terms of the space, but these kind of movements were already happening before the regulatory, before the Royal Commission. A number of them were, for example, the Productivity Commission's capability review in 2016 already identified these issues. You had the Audit Office already looking into it. You had Senate committees looking into it. And it's been a consistent theme that's been underlying the Royal Commission, regardless of whether it's occurred or not. I think really it's been the benefit of the Royal Commission has been to give it that public push, a public effective impetus that has put it into the public spotlight and really made enforceable undertakings a commonplace term within the industry and the public more generally.
One of the related questions I have is, you've got a lot of material about questioning enforceable undertakings, but from a broader perspective, and they're not really that unusual, are they? Because in criminal cases, the vast majority of cases are pled out. I mean, that's essentially a negotiated settlement, as is an enforceable undertaking. And a particularly good example you gave was the Rich case, where ASIC essentially lost $35 million, spent a couple of years in court, and had a complete failure. So cases like the Rich one illustrate that when ASIC gets it wrong, it doesn't just lose, it loses big time. Whereas an enforceable undertaking, as imperfect as it is, costs not even a tenth of something like the Rich case, and you get some sort of adverse penalty. So if it's the same reason people plead out criminal cases. Who wants a 6-month trial when you can have a 6-day plea hearing? It saves everybody money, and in a plea hearing, the person gets a lesser sentence because they've saved money and cooperated. So are the sort of weak compromises that we see in enforceable undertakings, are they just another example of the compromises we see everywhere else in the legal system?
I think in a sense they are, but the advantage I think of an enforceable undertaking as opposed to a traditional form of settlement is that it's much more targeted and it's a lot more public and transparent because they are published on the ASIC register and they're there for posterity. I think they can target a remediation outcome much more effectively because they can get a promisor to actively put in a remediation outcome, actively develop a remediation program to compensate XYZ customer. And it's the monitoring effect of those enforceable undertakings that's different to the traditional settlement approach, because their independent auditors and independent assessors do come in and regularly assess compliance of EUs. And they can, once an EU has been breached, then it can be taken to court again, etc. So I think it's slightly different in the sense, obviously, so a lot of those points that you mentioned do apply to the enforceable undertakings. But I think it adds an extra element of transparency and a way in which you can monitor, which isn't necessarily an approach that's found in traditional forms of settlement.
One final question, which it's not necessarily a criticism of your paper, but I think your paper begs the question, and it comes from the way you describe enforceable undertakings. They're essentially remediation regimes, and they're monitored. The contrast I see with cases like the Rich case is that they're essentially civil prosecutions designed for punishment. So is one of the key distinctions you see in enforceable undertakings that they're cooperative remedial exercises rather than judicial punishment pursuits?
I think I can agree with that contention because it is a much, I mean, it's inevitable that it's a much more softer form of punishment. They they are described in that academic study, for example, as being penal in the sense that it costs a lot of time to defend those and negotiate those outcomes. And they certainly are taken very seriously in the industry. But from a legal standpoint, they are not necessarily punitive in a sense. And which is why I think the enforcement pyramid is so important, because you have, at the base of the pyramid, you have these kind of enforcement undertakings and softer persuasion tactics that are used in cases where it's not necessarily needed to have that sort of heavy-handed litigation approach that costs a lot. But yes, delivers deterrence effects, but at what cost? Those kind of deterrence effects should only be left for the most egregious offences, and they should be, the focus of the courts, etc. Instead of lower level ones that should have, it be more. It lends itself to more remediation-based outcomes because of the nature of the customer affected. So I think they should be used as complements and not substitutes in line with the enforcement pyramid.
Thank you for that presentation. As we've said before, the effectiveness of a presentation such as this should be measured with reference to both the mastery that you obviously have, an impressive mastery of the subject matter itself, but also the way that you're able to convey those core messages to your audience here in the room today. Given what I've said and given what we've seen in the context of your mastery, I'm going to now just make some comments about the translation of that message to your audience. And I'll just say a few simple things about that given the time. In terms of your style, I think that the first thing we should celebrate is that, that you effectively didn't use any notes throughout the entire presentation. And I think that that's a really important thing for us to note, because that's no small task. And I do really take my hat off to you, because I think it's a very difficult thing to do. I do think, though, that there are some cautions and caveats to be conscious of when you choose not to use notes. And one of those things is that there can be a tendency to search for the next thought by looking elsewhere other than the audience. Sometimes I noticed that your tendency was to look down and to gather that next idea before you continue to speak. But the only risk there is that you're not connecting with the people. And that's why you're here, to tell us about what we need to care about. So that's just one thing to bear in mind, but very important to say that, fantastic effort not to be using those notes as a crutch. The other thing I'd say was that I loved the way that from the very outset you moved away from the lectern and you were very personable in that context, so that was very good indeed. That was two comments on style. Now I'm going to say something about the slide content. I did think that they tended to be busy. There was a lot of information there. For example, the why not litigate slide had many words. Perhaps there may have been a more visual way of anchoring the so what factor for the audience, because at the end of the day we can recall 3 key things maximum from your presentation. That's the case with any presentation. So we need to make sure that those things count. So less is more in the context of those messages. I liked the headline slides, the grabs, just to sort of the movability of the newspaper headlines was really interesting and situated the topical relevance really nicely. Your voice, very calm and very, reflective of the fact that you do have that mastery that I spoke to before. However, your challenge is to make sure that each of your sentences remain fully intact and that the end of the sentence doesn't fall away before the next sentence begins. And an example where that happened, and I had to work hard to understand what the final part of the sentence was when you were speaking to what was considered a criminal or a civil penalty. And I didn't hear civil or penalty, but I just deduced what it was that you meant. Finally, in terms of structure, I think the presentation would be enhanced by clearer signposts. There were some throughout the talk. I say this in the spirit of always wanting to take your audience on the journey that you're clearly able to take us on, because you have that very sound understanding and knowledge. So just be conscious of always taking the audience with you.
Yeah, a couple of things I'd second on that. From the start I thought, oh my God, this speaker has legs. as he's moved out from the podium. I think that's particularly noticeable, and I think what that does is it establishes a level of confidence, and it's not necessarily to criticise the other speakers, but as people get more confident and familiar with this sort of speaking, they move away from the lectern, and I think we're particularly conscious of that as academics, because you go to a conference and you see the people who speak as you did and the other people who hide behind the lectern. The other thing I thought was the tone of voice was very effective and well judged, and for a moment I thought, oh, this smoothie is going to try and sell me a timeshare. But I think the tone of your delivery was really well modulated, and also exuded confidence. And the other thing I'd endorse is the movable PowerPoints. Because I think one of the tricky things with PowerPoint is not enough or too much. Some little toys to keep people amused, but not so many that they get distracted. And I think on that, your PowerPoints struck just the right amount of detail. And there are a couple that were fairly detailed, but what was useful was that you didn't sort of read them or labour them. You essentially left various detail there for the convenience of the reader, and then it was followed perhaps by another one when you saw photos of people. So there was balance in the individual PowerPoints, but overall there was a really good and well judged level of variety in them.
Thanks very much.